Jurisdiction over cases covered by barangay conciliation. In certain cases, conciliation in the barangay is required before going to court. In the barangay level, the parties try to settle their issues, and in case of failure to settle, the barangay will issue a certification for filing of a complaint in court, or in short, a certification to file action, which will be used by the plaintiff or the complainant as proof that he or she complied with a condition precedent of barangay conciliation, but it failed. That is why the plaintiff or the complainant is filing a case in court. Otherwise, non-compliance with a condition precedent may be a ground for the dismissal of a case. So what is the rule? Section 412 of RA 7160, or the Local Government Code, making conciliation a precondition to the filing of complaints in court, read, "No complaint, petition, action, or proceeding involving any matter within the authority of the lupon shall be filed or instituted directly in court or any other government office or for adjudication unless there has been a confrontation between the parties before the lupon chairman or the pangkat, and that no conciliation or settlement has been reached, as certified by the lupon secretary or pangkat secretary, as attested to by the lupon chairman or pangkat chairman, or unless the settlement has been repudiated by the parties thereto." Are there instances when the parties can go directly to court without undergoing barangay conciliation? Yes. The same law provides that the parties may go directly to court in the following instances: where the accused is under detention, where a person has otherwise been deprived of personal liberty, calling for habeas corpus proceedings, where actions are coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property, and support pendente lite, and where the action may otherwise be barred by the statute of limitations. What is the rule for conciliation among members of indigenous cultural communities? The customs and traditions of indigenous cultural communities shall be applied in settling disputes between members of the cultural communities. Question: what is the subject matter for amicable settlement? The lupon of each barangay shall have authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes. Are there exceptions? Of course, there are exceptions. So what are the exceptions? Amicable settlement is not required in the following cases: where one party is the government or any subdivision or instrumentality thereof, where one party is a public officer or employee and the dispute relates to the performance of his official functions, offenses punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos, offenses where there is no private offended party, where the dispute involves real properties located in different cities or municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. Disputes involving parties who actually reside in barangays of different cities or municipalities, there is no need for amicable settlement in the barangay, except where such barangay units adjoin each other and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon, and such other classes of disputes which the President may determine in the interest of justice or upon the recommendation of the Secretary of Justice. Where is the venue of barangay conciliation? Disputes between persons actually residing in the same barangay shall be brought for amicable settlement before the lupon of said barangay. Those involving actual residents of different barangays within the same city or municipality shall be brought in the barangay where the respondent or any of the respondents actually resides at the election of the complainant. All disputes involving real property or any interest therein shall be brought in the barangay where the real property or the larger portion thereof is situated. Those arising at the workplace, where the contending parties are employed, or at the institution where such parties are enrolled for study, shall be brought in the barangay where such workplace or institution is located. Objections to venue shall be raised in the mediation proceedings before the punong barangay, otherwise, the same shall be deemed waived. Any legal question which may confront the punong barangay in resolving objections to venue may be submitted to the Secretary of Justice or his duly designated representative, whose ruling thereon shall be binding. Let us discuss the case of Zamora versus heirs of Izquierdo, GR number 146195, November 18, 2004. So in this case, the Supreme Court held that the primordial objective of Presidential Decree number 1508 or the Katarungang Pambarangay Law, now included under RA number 7160 or the Local Government Code of 1991, is to reduce the number of court litigations and prevent the deterioration of the quality of justice which has been brought about by the indiscriminate filing of cases in courts. In this case, the punong barangay, as chairman of the Lupong Tagapamayapa, conducted conciliation proceedings to resolve the dispute between the parties. However, petitioner contends that the Lupon conciliation alone, without the proceeding before the pangkat ng tagapagkasundo, contravenes the law on Katarungang Pambarangay. The Supreme Court held that the records show that confrontations before the barangay chairman were held on several occasions. Hence, to require another confrontation at the barangay level as a sine qua non for the filing of the instant case would not serve any useful purpose anymore, since no new issues would be raised therein, and the parties have proven so many times in the past that they cannot get to settle their differences amicably. The Supreme Court cited Section 412A of RA number 7160 or the Local Government Code, which provides that as a precondition to filing a complaint in court, the party shall go through the conciliation process either before the Lupon chairman, as what happened in this case, or the pangkat. Okay, take note, either the Lupon chairman or the pangkat. The Supreme Court further held that, notwithstanding the mandate in Section 410B of RA number 7160 or the Local Government Code that the barangay chairman shall constitute a pangkat if he fails in his mediation efforts, the same Section 410B should be construed together with Section 412A of the same law, which provides for the lupon or the pangkat, as well as the circumstances obtaining in and peculiar to the case. Here, while the pangkat was not constituted, however, the parties met how many times? 9 times at the office of the barangay chairman, where the parties' issues were discussed. It is thus manifest that there was substantial compliance with the law, which does not require strict adherence thereto. Pascual versus Pascual, GR number 157830, November 17, 2005. In this case, the Supreme Court held that in the 1982 case of Tavora versus Veloso, the court held that where the parties are not actual residents in the same city or municipality or adjoining barangays, there is no requirement for them to submit their dispute to the lupon as provided for in the Katarungang Pambarangay Law. In the 2000 case of Versidi versus Hernandez, the court, noting that the Tavora ruling was decided under the provisions of the Katarungang Pambarangay Law, which were, except for some modification, echoed in Section 408 to 409 of the Local Government Code, which took effect on January 1, 1992, the Supreme Court held that the Tavora ruling remained. So in other words, it still is applicable where the parties are not actual residents in the same city or municipality or adjoining barangays. There is no requirement for them to submit their dispute to the lupon. Abagatnan versus Spouses Clarito, GR number 211966, August 7, 2017. Petitioners raised the sole issue of whether the Court of Appeals correctly dismissed the complaint for failure to comply with the Barangay Conciliation requirement under Section 412 of the Local Government Code, despite the fact that not all real parties in interest resided in the same city or municipality. Or in other words, when not all real parties in interest reside in the same city or municipality, is there a need to comply with Barangay Conciliation? The Supreme Court held that the Local Government Code provides that the lupon of each barangay shall have the authority to bring together the parties actually residing in the same city or municipality for amicable settlement of all disputes, subject to certain exceptions, such as where the dispute involves parties who actually reside in barangays of different cities or municipalities, unless said barangay units adjoin each other and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. Thus, parties who do not actually reside in the same city or municipality or adjoining barangays are not required to submit their dispute to the lupon as a precondition to the filing of a complaint in court. The Supreme Court held that in the present case, the complaint filed before the MTCC specifically alleged that not all the real parties in interest in the case actually reside in the city or in the same city. One resided in Poblacion Siniluan, Laguna, while the other resided in Barangay de la Paz, Pasig City. As such, the lupon has no jurisdiction over their dispute, and prior referral of the case for Barangay Conciliation is not a precondition to its filing in court. Furthermore, this is true regardless of the fact that the two parties had already authorized their sister and co-petitioner to act as their attorney-in-fact in the ejectment proceedings before the MTCC. Why? As explained by the court, the residence of the attorney-in-fact of a real party in interest is irrelevant insofar as the actual residence requirement under the local government for prior barangay conciliation is concerned. Okay? So whose actual residence is relevant? It is the actual residence of the real party in interest and not the attorney-in-fact. Heirs of Orito versus Montes Claros, GR number 168935, March 13, 2013. In this case, the Supreme Court held that the compulsory process of arbitration is a precondition for the filing of the complaint in court, where the complaint did not state that it was one of accepted cases, or where it did not allege prior availment of said conciliation process, or where it did not have a certification that no conciliation had been reached by the parties, the case should be dismissed. Because petitioners in this case, in their amended complaint, did not state that it was one of accepted cases, the dismissal of the complaint was proper. Aquino versus Aure, GR number 153567, February 18, 2008. The issue in this case is non-compliance a jurisdictional effect, or in other words, whether or not compliance with the barangay conciliation proceeding is a jurisdictional defect that warrants the dismissal of the complaint. The Supreme Court in this case held that there is no dispute that the present case was never referred to barangay conciliation before Aure and Aure Lending instituted a civil case. In fact, no allegation of such barangay conciliation proceedings was made in the complaint before the METC. The only issue to be resolved is whether non-recourse to the barangay conciliation process is a jurisdictional flaw that warrants the dismissal of the ejectment suit filed with the METC. Aquino posits that failure to resort to barangay conciliation makes the action for ejectment premature and hence dismissible. She likewise avers that this objection was timely raised during the pre-trial and even subsequently in her position paper submitted to the METC. The Supreme Court held that it is true that the precise technical effect of failure to comply with the requirements of barangay conciliation is much the same effect produced by non-exhaustion of administrative remedies. The complaint becomes afflicted with the vice of prematurity, and the controversy there alleged is not ripe for judicial determination. The complaint becomes vulnerable to a motion to dismiss. Nevertheless, the conciliation process is not a jurisdictional requirement, so that non-compliance therewith cannot affect the jurisdiction which the court has otherwise acquired over the subject matter or over the person of the defendant. What is the effect if there is failure to object to the non-compliance of the barangay conciliation? The Supreme Court held that Aquino cannot be allowed to attack the jurisdiction of the METC over the civil case after having submitted herself voluntarily thereto. The court held that it has examined Aquino's answer before the METC, and there is utter lack of any objection on her part to any deficiency in the complaint which could oust the METC of its jurisdiction. The court quoted the Court of Appeals. Moreover, the court takes note that Aquino herself did not raise in defense the aforesaid lack of conciliation proceedings in her answer, which raises the exclusive affirmative defense of simulation. By this acquiescence, defendant or Aquino is deemed to have waived such objection. As held in a case with similar circumstances, the failure of a defendant in an ejectment suit to specifically allege the fact that there was no compliance with the barangay conciliation procedure constitutes a waiver of that defense. So by Aquino's failure to seasonably object to the deficiency in the complaint, she is deemed to have already acquiesced or waived any defect attendant thereto. Consequently, Aquino cannot thereafter move for the dismissal of the ejectment suit for Aure and Aure Lending's failure to resort to barangay conciliation process, since he is already precluded from doing so. The fact that Aquino raised such objection during the pre-trial and in her position paper is of no moment, for the issue of non-recourse to barangay mediation proceedings should be impleaded in her answer. As provided under Section 1, Rule 9 of the 1997 Rules of Civil Procedure, defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. While the quoted provision applies to a pleading, specifically an answer or a motion to dismiss, a similar or identical rule is provided for all other motions in Section 8 of Rule 15 of the same rule. It states that subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. Question: can there be a motu proprio dismissal of a case where there is failure to comply to barangay conciliation? The Supreme Court held that neither could the METC dismiss the civil case motu proprio. The 1997 Rules of Civil Procedure provide only 3 instances when the court may motu proprio dismiss a claim, and that is when the pleadings or evidence on the record show that the court has no jurisdiction over the subject matter. There is another cause of action pending between the same parties for the same cause, or where the action is barred by a prior judgment or by a statute of limitation. Thus, it is clear that a court may not motu proprio dismiss a case on the ground of failure to comply with the requirement of barangay conciliation, this ground not being among those mentioned for the dismissal by the trial court of a case on its own initiative. Lansangan versus Kaisip, GR number 212987, August 6, 2018. So also in this case, the question of whether or not there is a motu proprio dismissal for non-compliance of barangay conciliation was discussed. So here, the ground of non-compliance with a condition precedent that is undergoing prior barangay conciliation proceedings was not invoked at the earliest opportunity, as in fact, respondent was declared in default for failure to file a responsive pleading despite due notice. Therefore, it was grave error for the courts ACO to order the dismissal of petitioner's complaint on said ground. Hence, in order to rectify the situation, the court finds it proper that the case be reinstated and remanded to the MCTC, which is the court of the origin, for its resolution on the merits. Bonifacio Law Office versus Bellucilio, AM number MTJ 001308, December 16, 2002. The facts of this case are as follows. The complaint before the barangay was dated February 16, 1996. Records show that the hearing was scheduled for February 26, 1996, and was reset for February 29, 1996. And yet, the certification to file action was issued on March 1, 1996, less than 15 days after the first scheduled hearing before the barangay chairman. Complainant contends that he has complied with the mandatory barangay conciliation proceedings as evidenced by the certification to file action attached to the complaint for ejectment. The issue in this case is whether there was compliance with the barangay conciliation requirement. The Supreme Court held that the records reveal that such certification was improperly and prematurely issued. In what appears to be a pre-printed standard form thereof, the X before the second enumerated statement clearly shows that no personal confrontation before a duly constituted pangkat ng tagapagkasundo took place. Respondent's position that the pangkat was not constituted and that no face-to-face conciliation of the parties had taken place before it is substantiated by the minutes submitted by complainant. Evidently, complainant failed to complete the barangay conciliation proceedings. Specifically, the Supreme Court cites Section 410B of the Local Government Code. Upon receipt of the complaint, the Lupon chairman shall within the next working day summon the respondent with notice to the complainant, for them and their witnesses to appear before him for a mediation of their conflicting interests. If he fails in his mediation effort within 15 days from the first meeting of the parties before him, he shall forthwith set a date for the constitution of the pangkat in accordance with the provisions of the law. Furthermore, Administrative Circular number 14-93 provides that in order that the laudable purpose of the law may not be subverted and its effectiveness undermined by indiscriminate, improper, and/or premature issuance of certifications to file actions in court by the Lupon or Pangkat secretaries attested by the Lupon or Pangkat chairman, respectively, the following guidelines are hereby issued for the information of trial court judges in cases brought before them coming from the barangays. So one of these guidelines include that all complaints and/or informations filed or raffled to the sala or branch of the regional trial court, metropolitan trial court, or municipal trial court shall be carefully read and scrutinized to determine if there has been compliance with prior barangay conciliation procedure. Okay? In this case, evidently, The barangay failed to exert enough effort required by law to conciliate between the parties and to settle the case before it. Hence, respondent judge was not incorrect in remanding the case to it for completion of the mandated proceedings. We cannot fault him for seeking to promote the objectives of barangay conciliation and for taking to heart the provisions of the Supreme Court Circular number 14-93. His referral of the case back to the barangay cannot be equated with gross ignorance of the law. Neither does it constitute grave abuse of discretion or obvious partiality. Thereafter, complainant filed a motion praying that the proceedings already held before the barangay be considered as substantial compliance with the requirements of law. Acting on the motion, respondent judge issued the summons and opted to continue with the court proceedings without insisting on strict compliance with the mandated barangay proceedings. The Supreme Court held that he did so after noting that complainant was apparently not making any move to complete the barangay proceedings after the case had been remanded to the barangay, and that the case fell under the rules on summary procedure. Racpan versus Baroga High, GR number 234499, June 6, 2018. In this case, the Supreme Court held that as for petitioner's failure to resort to barangay conciliation, Section 412 of the Local Government Code provides that parties may go directly to court where the action is coupled with provisional remedies. Okay? While there is no dispute that the present case was never referred to Barangay Lupon for conciliation before petitioner instituted the civil case, there is likewise no quibbling that his complaint was coupled with a prayer for the issuance of a preliminary injunction. Hence, it falls among the exceptions to the rule requiring the referral to barangay conciliation. As good faith is always presumed, in the absence of proof of improper motive on the part of the petitioner, the court cannot countenance the appellate court's assumption that petitioner was solely intent on evading the requirements of the Local Government Code in applying for a preliminary injunction, because this is the usual thing, as they say. If you want to go directly to court, just include a provisional remedy to avoid the requirement of barangay conciliation. But the court held that good faith is always presumed. So it said that it cannot sustain a dismissal of an action on account of an unproven assertion of bad faith. Marino versus Spouses Salcedo, GR number 138141, November 15, 2000. In this case, the Supreme Court held that we agree with the ruling of the Court of Appeals that the complaint of the respondent should not have been dismissed for lack of prior barangay conciliation. For one, the court cannot sustain private respondents that there was no compliance with the requirement of prior barangay conciliation. From the factual antecedents of the case, it cannot be denied that there was already substantial compliance with the requirements, which does not require technical compliance with its procedural requirements. The moment private respondents sought possession of the mortgaged property by filing a motion of execution before the trial court, it was already manifest that they were not amenable to a settlement of the case. In fact, the certification dated July 26, 1994, issued by the barangay captain that the matter had already been brought to the office of the barangay captain would suffice. Private respondents have already exhibited their unwillingness to settle the matter, and referral of the controversy before the barangay for the second time will not only result in a circuitous procedure, but will necessarily entail undue and further delay. This is inevitable if the court should sustain the dismissal of the complaint and require the parties to meet before the barangay, only to bring the case all over again to the court for decision on the merits. Magno versus Velasco Jacoba, AC number 6296. This is a resolution on November 22, 2005. So in this case, the Supreme Court cited Section 415, Appearance of Parties in Person. In all katarungang pambarangay proceedings, the parties must appear in person without the assistance of the counsel or representative, except for minors and incompetents who may be assisted by their next of kin who are not lawyers. The quoted provision clearly requires the personal appearance of the parties in the katarungang pambarangay conciliation proceedings unassisted by counsel or representative. The rationale behind the personal appearance requirement is to enable the lupon to secure first-hand and direct information about the facts and issues, the exception being in cases where minors or incompetents are parties. There can be no quibbling that laymen of goodwill can easily agree to conciliate and settle their disputes between themselves without what sometimes is the unsettling assistance of lawyers, whose presence could sometimes obfuscate and confuse issues. Worse still, the participation of lawyers, according to the Supreme Court, with their penchant to use their analytical skills and legal knowledge, tend to prolong instead of expedite settlement of the case. The prohibition against the presence of a lawyer in a barangay conciliation proceedings was not, to be sure, lost on respondent. Her defense that the aforequoted Section 415 does not apply since complainant addressed her sumbong to the barangay captain of Barangay San Pascual, who thereafter proceeded to hear the same, is specious at best. So in this regard, suffice it to state that complainant wrote her sumbong with the end in view of availing herself of the benefits of barangay justice. That she addressed her sumbong to the barangay captain is really of little moment since the latter shares the lupong tagapamayapa. Lest it be overlooked, the prohibition in question applies to all katarungang pambarangay proceedings. Section 412A of the LGC clearly provides that as a precondition to filing a complaint in court, the party shall go through the conciliation process before the lupon chairman or the lupon or pangkat. As what happened in this case, the punong barangay, as chairman of the lupon tagapamayapa, conducted the conciliation proceedings to resolve the disputes between the two parties. Okay? Given the perspective, the Supreme Court joined the IBP Commission on Bar Discipline in its determination that respondent transgressed the prohibition prescribed in Section 415 of the Local Government Code. However, its recommended penalty of mere admonition must have to be modified. Doubtless, respondents' conduct tended to undermine the laudable purpose of the katarungang pambarangay system. What compounded matters was when respondent repeatedly ignored complainant's protestation against her continued appearance in the barangay conciliation proceedings. So, okay, again, appearance of parties in person must not be accompanied by a lawyer in the barangay